A little paper. It was an editorial written by Paul Baker, Sarah Anderson, and me, which came out in the British Journal Anaesthesia. We philosophers think of the BJA as being the British Journal of Anaesthetics, so I have to of aesthetics. So I have to work a bit to get the title here. So what I'm going to do is basically talk through this little editorial, and then hopefully have some time for some questions. So begin with a hypothetical. This is actually a case. So Paul Baker, who is an anaesthetist, was presenting to a group in a place not to be named. So we're keeping everything this bit of it anonymous. And someone in the audience actually said they found themselves in this situation. So they were an experienced adult anaesthetist, the only skilled airways practitioner available, when an infant presented with an obstructed airway. The kid was deteriorating rapidly and required an e-phoner to survive. The anaesthetist had never performed an e-phoner on anyone, and their last training was on an adult mannequin about 4 years previously. They knew the child would die without urgent intervention, but they feared that the child would suffer permanent brain damage or die if the e-phoner went wrong. So they were under a lot of stress, feeling responsible for this child, and had to decide what to do. And so the question is, what should that person have done? And the audience that Paul was talking to was fairly evenly divided between thinking they should have had a go, notwithstanding their lack of confidence and concern on the one hand, and other people thinking, well, they were entitled, given their lack of experience, the lack of expertise, to say no. And so we tried to go through this and see what we thought of it from philosophical, legal, and ethical perspective. Now, I should just make clear, so as Steve said, I'm a philosopher. I have no medical training at all. So I'm not talking about won't talk about the medical bits if I can help it. Let me know, of course, if I get anything terribly wrong. But essentially, those bits were written by Paul and Sarah, who both have medical backgrounds. So the place we began was with competence and scope of practice, and just begin with the observation that this is really a fundamental legal and ethical obligation. So as it's put in your good medical practice guidelines, and New Zealand's is exactly the same, essentially, you must recognise and work within the limits of your competence. That obligation is grounded in a broad obligation to provide benefit and avoid harm. So you can deliver benefits to people only if you are doing things you're competent to do, and of course you avoid harm if you are acting within your area of competence. But it's also worth seeing this a little more broadly, I think, from the patient's point of view. And what I've done elsewhere is defended this account of client-professional relationships. So I write a bit about medical ethics, but I also write about professional ethics more generally, and legal ethics in particular, since my professional background is in law. And it seems to me that client-professional relationships, and so doctor-patient relationships, are marked by these four features. There's always an imbalance of power and expertise. So the professional, the doctor, the lawyer, the what have you, has power, and so can do things, and has knowledge that the client or the patient needs. Now, sometimes that power is de facto. So as doctors, you simply know things that I don't, as a non-doctor, as a layperson, so you have knowledge. So in fact, you have power and expertise that I lack. And sometimes it's de jure, that is, as a matter of law. So as doctors, you can prescribe things that I can't prescribe because I'm not a doctor. But so those combination of de facto and de jure, or in fact and in law, features give you power and expertise that I lack as a patient when I'm a patient, and clients lack. The second thing is that when we're talking about professionals like doctors or lawyers, then the issues which are at stake are always important. Now, professional, sometimes we use the term professional to mean someone just does something for money. So you can be a professional rugby player or a professional cricket player or what have you, cricketer. But in the sense, the vocational sense in which we talk about doctors or lawyers, the issues are always important. They're our health, the security of our assets, our rights and liberties, the well-being of our family, and so on and so on. So they're always important. And third, and I think this is maybe the crucial one, there's an opacity of diligence and expertise as far as the client goes. So in most of my dealings with people who are doing things for me, mechanics, electricians, what have you, I can tell pretty quickly whether they know what they're doing. It's not that incompetence is always trivial, it needn't be, but usually I take something to get it fixed and I can tell whether they fixed it. If I go and see a professional, so a doctor in my case, let's suppose, I have no idea at the end of the day whether the doctor has done a good job or not. Because, I might go through all sorts of things with them and they might say, well, look, I'm sorry, we've done our best, but there's simply nothing to be done to help you. And I can't tell whether that's because the condition is such that there's nothing to be done, the best doctor in the world couldn't do anything about it, or whether my doctor just happens to be not very good. Now, this is one of the reasons, incompetent professionals, and not just doctors, but lawyers, so my profession, can get away with practicing for a long time. You can't tell by the outputs whether they are being diligent and have the appropriate expertise. And so there's this peculiar opacity around professional diligence and expertise. And finally, I think there's, in almost all cases, especially probably professions like anaesthetists, where if my experience is anything to go by, you encounter them in hospitals, you don't know anything about your doctor as a person. So even my GP, I don't know much about her. Particularly, she has, photos of kids on her desk, but I have no idea whether they're hers really. I don't have those sorts of conversations with her. Certainly the anaesthetist I meet at the hospital, I know nothing about them. So the result of all of that is very striking. The clients of professionals, e.g. doctors, are obliged to rely upon relative strangers for things that are important when they can't assess the expertise or diligence with which their important interests have been pursued or protected. So there are a bunch of things that follow from this, and one, most strikingly, it makes clear how vulnerable the clients of professionals and patients are to their professionals. But it also, another thing that follows is that we relate to professionals as role occupants. So I don't relate to the anaesthetist I meet at the hospital as an individual, as a person. I relate to her as an anaesthetist, as a doctor. And so what I know about her is really what I know about the role. So I have beliefs about people who can hold themselves out as doctors. I believe she's a doctor. That's what I know about her. It's not an individual thing. It also makes clear why the medical profession has to take the role or take on the weight of ensuring that practitioners are appropriately trained and competent. Patients can't check that for themselves. There's just no way that they can assess the diligence or competence of their expertise. It's got to be done by other people who already have that diligence and expertise. And so that's where the medical profession comes in. And finally, it makes clear that it's up to the doctor themselves to ensure that they act within their area of competence, because I can't do anything about it. So it's really, there's a heavy moral obligation on doctors and professionals more generally to make sure that they're acting within their area of competence. All right, so that's the sort of starting place for this. So next, there's a particular kind of challenge if you're talking about competence around something like ephona. I'm just assuming that's how that's pronounced, by the way. So I'm not a medical person, but there's a particular challenge, and that is that most practitioners, I'm advised, will never perform an ephona on an adult, let alone an infant. So you might go through an entire career and never be called upon to perform this emergency procedure. And doing this on an infant may be outside the scope of practice for almost all airways practitioners. And we'll talk briefly about training and so on, how you might address this. But that's a problem if you think that you're obliged to act within your area of competence, and we think this is outside the area of competence of almost everyone. Now, just briefly, there might be a more general challenge here, and that is both in medicine and maybe most professions, certainly in law, there's been this trend towards super specialization. I don't know whether this happens to doctors, but if I'm out somewhere and say I happen to have a law background, after class, for instance, people always come up to you and ask you questions about their grandmother's will and so on, or intellectual property, and they never quite believe that I don't know anything about intellectual property. They think if you're a lawyer, you're a lawyer, and lawyers know everything. But of course, that's false. And so the more and more specialized people become, the more likely it is that we'll have these problems around scope of practice and competence. There'll be more likely people will encounter things. So I think Paul probably wrote this paragraph that's up there when he says, even calling for help from a surgeon may not be very useful unless a paediatric surgical airway specialist is available. Your general surgeon may be not much better positioned to help than the adult airway practitioner. Now, there is almost everywhere an emergency exception. So there's legal and ethical flexibility to allow delivery of treatment outside your normal scope practice in emergencies. So this, again, is from your guidelines. Helping in emergencies, you must help in an emergency, very strong obligation, though taking into account your own safety, your competence, and the availability of other options for care. And we'll talk about some of those exceptions in a second. But there's an exception. In New Zealand, there's a very explicit legislative link between the obligation to act within your scope of practice and this emergency exception. So our Health Practitioners Competence Assurance Act says every health practitioners must not practice outside their scope of practice. You've got to have a current practicing certificate. You've got to act within your scope of practice, except Section 3, none of that applies in an emergency. So it's quite clear that emergencies are an exception. Now, as far as I know, and I confess being slightly nervous about this, there's no UK equivalent of the New Zealand Health Practitioners Competence Assurance Act. And I'm happy to be told if I'm wrong, but I had a hunt for this when we were writing this. I couldn't find anything. What you do have is this wonderfully named SARA Act, the Social Action Responsibility and Heroism Act, which basically requires courts considering claims of negligence or breach of duty to ask whether the person was acting for the benefit of society or acting altruistically or heroically, basically. And that act has been applied in at least one case with a medical student in the UK who intervened in having come across a car accident or a vehicle accident where it was clear that this was really beyond his or her competence. I can't remember what it was. But so that maybe is your version. But as far as I know, you don't have a specific act. Now, these things will always involve judgment, of course, and so this isn't in the paper, but you can imagine, a philosopher and obstetrician are the first on the scene of a serious car accident. Let's suppose that the obstetrician knows nothing about trauma medicine. Still, it's no doubt better that she intervened than the philosopher, or nobody, since after all, she is a doctor and she'll have a lot of basic knowledge that the philosopher will lack. And you might have thought in this case, our case, though the practitioner has never performed an ePhoner, still, unless on a paediatric patient, nonetheless, they may be the best qualified and experienced person available. So it's better that they intervened in the obstetrician or no one. And so that's, I take it, the point of that clause. You must offer help taking into account your competence and the availability of other options for care. So these things will require a judgment. Now, both the UK and the New Zealand guidelines also say that you should have regard to your own safety when deciding to help in an emergency. Now, the obvious risks are things like car accidents, presumably, and fires, where you're not expected to put yourself at risk of physical harm when attempting to rescue or resuscitate a trapped passenger. There's no threat to the doctor's physical safety in our hypothetical case. But we've stipulated that the anaesthetist does feel extremely stressed, and there's lots of research to show that stress affects the psychological and physical well-being of doctors and other health professionals. So maybe that's relevant. The authors were somewhat divided on this. At least one of us, and that may well have been me, thought that the stresses associated with our hypothetical were not analogous to those to live power lines or fire. So I thought doctors are not trained or equipped to deal with fire or power lines, but their training should allow them to deal with stress associated with their core roles. So, no doubt this is a stressful situation, but it's a stressful situation of a kind that you would think the medical professional should be able to deal with. So I wondered whether the capacity to cope with predictable stressors or should be regarded as a core competence of the doctor's role. It's one of the things that they should just have to manage. Now, there are other ways that stress and fear and so on might be relevant. Uncertainty and stress can impair competent decision-making and performance. So we know if you put people under stress, they perform worse than they do if they're not under stress. But there's some very interesting literature around this stuff. And one suggestion is that what people under stress do is make an assessment of the demands that they are required to attain a desired goal, avoid the plane crashing, save the child, what have you. They then assess their personal and environmental resources that they have available to them in order to meet those demands. And if they judge the resources to be sufficient, then stress can actually positively affect performance. So if they think about it and think, yes, I have everything I need, including expertise and competence, then the stress may actually make them better. But if they assess the resources, including their own competence and confidence and expertise, as insufficient, then distress ensues. And that triggers a variety of psychological and physiological responses that can actually make them perform worse. So kind of interesting stuff here. A connected issue here. So I've said, or we said, the practitioner fears that the child might be seriously harmed if the procedure goes wrong. But there's another failure which bears on this and which threatens a harm, which touches the practitioner more directly themselves. And that is the fear of failure and shame itself. So we experience shame when we believe that we have failed to meet ideals or standards that we've come to accept, that we understand ourselves in terms of. And the higher the standards we set for ourselves, the more powerless our lives can be. So the more likely it is that we will fail occasionally and feel the threat of shame. And we wonder whether this fear of failure and shame is a significant feature of the landscape in which medical practitioners work, and so a common motivation for avoiding risks. Medical professionals are high achievers, they're likely to have high standards, they're likely to have successful lives, and so they have higher standards than we philosophers, who make lives more easy for ourselves by not expecting so much of ourselves. Now, one thing we might do here, so this is education and checklist is really Paul's area of expertise, or one of his areas of expertise. One thing you might try and do, given that, is so if stress comes in where people feel they lack resources, you might try and give them the resources. And one way to do that is through training and so on, which makes them more likely to judge themselves as capable. And of course, that feeds into proposals to mandate EFONA training for airways practitioners, though this is very difficult because we know competence trails off, fades very quickly. I think Paul talks about 4 months after a training session, people return to the baseline before the training, and so it's difficult to keep this up. We might also give them checklists or cognitive aids to improve performance. Really, it's taking bandwidth, which makes it more likely. And less directly, you might just help clinicians by training to manage stress itself, is a more general thing. All right, so I want to finish by talking about a more philosophical issue, and that is this issue around acts and omissions. So you can imagine our airways practitioner thinking that it's better to refuse to intervene, to omit to do anything, even though they know the child will die, than to intervene, that is to act, and potentially, though unintentionally, cause the death of the child. You might think that it's better to allow someone to die through inaction than to have an active role in a death. And this is what we call the act omission doctrine, which has a long history in medicine and medical ethics. There's a problem, though. So here's a case which is meant to call that distinction into question. So imagine two wicked uncles. Each of them stands to benefit from a large inheritance if their respective infant nephew dies. They're each left in charge of bath time for their respective nephews. One wicked uncle takes advantage of the opportunity and pushes his nephew's head under the water, drowning him. The other, standing there, sees his nephew slip under the water and stands by until he drowns, even though he could just effortlessly, no risk to him, have pulled the baby out of the bath. So one acts to drown the baby, the other omits to allow the baby to drown, but deliberately. Now, the suggestion is that whether they act or omit doesn't make any moral difference. Both are motivated by greed and callousness. Morally, they and their behaviour seem equally bad. So acts and omissions is not the act and omission, it's something to do with the intention and with which people act or omit. Now, just note, it's not the uncle's wickedness that is the factor here. So here's a second case. Suppose there are two young men walking through a local park. They see a skateboarder out of control, careering down a path toward a small group of children. One of the men is on the path between the skateboarder and the children. He could easily step aside and save himself, but he deliberately doesn't do so. He stays there until the skateboarder runs into him. The other man is beside the path and deliberately acts, stepping between the skateboarder and the children. So both suffer minor injuries, both prevent injury to the children. Neither are wicked, of course. Now, again, whether they act or omit seems to make no moral difference. Morally, they and their behaviour are equally good. So the idea is that acts and omissions don't make any difference. It's something else. Now, it might seem that these philosophical thought experiments fail to acknowledge the different emotions which are likely to accompany decisions to act or omit. So actors, people who do something positive, may feel more responsible for outcomes than omitters, that people who omit. But notice that the decision to omit is itself an act. So the decision not to act is an act. So it's not as if that's the difference. And while people may have different emotional responses, if those cases are right, there's no moral difference between acts and omissions. So people shouldn't have different emotional responses, or if they do, then those emotional responses are morally irrelevant. So our practitioners shouldn't think that it's better to omit to be involved than to step in and run the risk that harm will result.